Hi everyone, this video is about a trickle of case law which has started to come through in relation to COVID-19 dismissals. I have recorded this video prior to England's opening game against Croatia, so at the moment I am in an optimistic and good mood. I appreciate that may well change depending on the result of the weekend. So the couple of cases I wanted to talk through, both linked in terms of the reasons for the claim and the legislation cited, two different outcomes. The first related to an employee who felt uncomfortable commuting and attending the office during lockdown. He asked to be furloughed. He was ultimately dismissed and claimed automatic unfair dismissal under Section 100 of the Employment Rights Act, which we will come on to. Now, ironically, in this case, the employer sold PPE. So bear in mind, he felt unsafe. The company probably did have some stocks of PPE to protect him. He asked either to work from home or to be furloughed, raising concerns about public transport and also working in the office. The company was too busy. They refused the furlough request on the basis that the scheme could not be justified given the workload that they had, and also confirmed the job could not be done from home. They did offer the employee the opportunity to take annual leave or unpaid leave, but he refused and instead presented three further requests to work from home and refused to attend in the meantime. He was ultimately dismissed. Now, he didn't have the right to claim ordinary unfair dismissal because he didn't have 2 years of service. What he instead alleged is that he'd been automatically unfairly dismissed under Section 101E of the Employment Rights Act, which is a section relating to health and safety. So to avoid the 2-year service requirement, if you can show you've been dismissed for having taken steps to protect yourself from immediate danger, you can potentially succeed in a claim. Now, the tribunal in this case considered the government's advice in that COVID-19 posed a serious and imminent threat to public health. The employee did raise concerns about commuting and working in an office, and he did have a reasonable belief that there were circumstances of serious and imminent danger as the section requires. However, part of the test under Section 100 requires him to take appropriate steps to protect himself from danger, and he did not do that. The demands that he made were not appropriate steps because the company could justify not placing him on furlough leave and not conducting the work from home. And he didn't take up the appropriate steps that the employer suggested, such as unpaid leave or using annual leave. The claim therefore failed on that basis. Contrast this with the case of Gibson, which has also recently come through the Employment Tribunal. Gibson was a chef in a restaurant. He was furloughed during the closures in 2020, and when they were able to reopen, he was asked to come into work. He raised concerns about the lack of PPE and other COVID-secure precautions. He was living with his father, who was clinically extremely vulnerable, and he was concerned about the transmission of the virus to him. The tribunal accepted the employee's evidence that he was simply told to shut up and get on with it. He was then dismissed with no notice or holiday pay via text message, with a suggestion from the employer that they were downsizing the team. Now, in this case, conversely, the tribunal held Mr. Gibson had been unfairly dismissed under Section 101E of the Employment Rights Act. He had taken steps to protect his father in what he reasonably believed to be circumstances of serious and imminent danger. He raised legitimate concerns which went unresolved, and he could have done no more prior to being dismissed, so appropriate steps were taken to try and protect himself and indeed his father. Points to take away from those cases. Firstly, and we've said this all the way through the pandemic, early engagement with staff is key. You have a legal obligation to make sure workplaces are COVID-19 secure, and if you publish and review that guidance to employees, consult with them as the government advice suggests, they're going to be more on board with coming into work, hopefully. If the employee has concerns, we need to discuss them. We need to make a decision as to whether those concerns are well-founded and genuine, and if so, adjustments should be put in place. Now, if those concerns are not genuine or are unreasonable, essentially the employee may then struggle to demonstrate there is serious and imminent danger any longer, and the business can be more confident about taking formal action if the employee continues to refuse to attend for work. That happened in the first case. We presented alternatives, the employee didn't take them on board, nothing more we could have done. If we have done everything reasonably expected of us as an employer, an employee might struggle to show they've taken appropriate steps to protect themselves by continuing to refuse to attend. Now, this issue is going to become more and more important at the point at which the work from home message is finally lifted and employees are invited back to the office. We know there is some general reluctance from a number of employees to come back from what may have been a long-term home working or furlough arrangement. And if you do need advice on that, or creating a COVID-19 secure environment, reviewing the measures you have in place, please do get in touch. employmenthub@chadlaw.co.uk or visit the website chadwicklawrence.co.uk. Thank you.